Good afternoon, Kavina.
Hi.
Nice to speak to you today. I appreciate you taking the time to speak to us about some exciting things you're doing.
Exciting, yeah.
To get started, maybe you can tell us a little bit as a background, just a little bit about the type of practice you have, the things you focus on, your area of expertise before we jump into the excitement you have coming up this week.
Sure. So I'm a lawyer at Loopster Dixon, which is a mid-sized law firm in Toronto, just north of the airport. We're basically a full-service business and public law firm. Probably close to 40 lawyers now, I would say. And I'm part of the estates and wills and estates practice group, where we deal with basically everything to do with wills, powers of attorney, trusts, family reorganizations, with respect to succession planning, et cetera. And I guess kind of a spin-off of my particular practice is also what I tend to phrase as elder law. So, all of those things that I just mentioned, but in the context of dealing with a more um, a senior person or an elderly person or a person perhaps that has limited mental capacity.
Excellent. So I've been reading a lot, and I've been noticing at Access Law as well that we've had a huge demand for clients wanting to have their wills drafted, updated, power of attorneys, estate planning, all sorts of things, particularly in the last 3 weeks or so since, coronavirus has been featured more and more prominently in the news and has become a larger part of our reality. Have you noticed the same trend as well in your practice?
Absolutely. It's been really busy here at the firm. We are getting inundated with, I would say, a few areas in particular. So on the business law side, there's a lot of influx with our corporate commercial team with respect to how business owners are dealing with this and accessing the relief from the government. Obviously, our employment law practice as well is really busy. And then on the wills and estate side, of course, people are concerned about incapacity and their loved ones and getting their affairs in order. I think that is partially because of the coronavirus, but also the sickness in and of itself, but also because people are at home and they're with their family and they have more time on their hands. And wills and estates tends to be one of those things that people put off and put off and put off, and every family wants to do it and they all know they should do it, but it's one of those things that unless there's a life event or a situational event, or someone in your family or extended family or a friend gets sick and dies, it doesn't really come to the forefront of your mind as something that you should do right away. So I think that the coronavirus and the staying at home situation has sort of moved that planning aspect up to the forefront of people's agenda.
I think you're absolutely right. And, we've noticed the same thing. I think what I most commonly hear from our clients are, oh my goodness, I've been meaning to do this for the last 10 years, the last 20 years. So you're right. It's these two kind of dual forces. One is, hey, I'm at home with my family and I might have the time and the inclination to do it right now, mixed with a little bit of, fear or apprehension of, what if I get sick? I should really have my affairs in order and whatnot. So I think that makes a lot of sense for sure. Now, one thing that I want to talk to you about today, and maybe we can just step back and look at the larger picture. I know that wills, in order to have them executed and probatable, for lack of a better word, but to actually be able to use them and appoint an executor, they need to be executed in a certain way. Absolutely. Now, we've always run into some smaller issues with that when we've tried to do wills virtually in the past, because we've been offering this service for a couple of years now, but you can't really execute by video conference. So maybe you could highlight for us a couple of the issues you've been having, and then we could talk about, some ways that we might be able to get around them.
Sure. So the execution of a will in Ontario comes with a very strict set of rules as to how that has to be done. And of course, I'm talking about non-holographic wills. So we're talking about wills that are not just done by the testator's hand and signed. Non-holographic wills are usually typed out, done by a lawyer or by the testator themselves. But the Succession Law Reform Act is the legislation that governs the execution of a will. And without getting into all the broad strokes of and technicalities, the actual signing of the will has to be done in the presence of two witnesses that are both present at the same time and that see the testator sign their will, and at the same and the testator has to see the two witnesses also sign their names on the will. So there's that signing procedure, and another avenue is for the testator to sign their will and then acknowledge their signature in the presence of two witnesses who are also both present at the same time. So whether it's signing in the presence or acknowledging in the presence, but this requirement of having two witnesses there at the same time is legislated.
Great. So basically no, that's perfect. So just to summarize what you were saying, to have a will, which is not a holographic will. So a holographic will is one written by hand, which you can it doesn't require witnessing, right? Most people like to have a nice typed out will, which requires two witnesses who are independent, such that they're not a beneficiary or married to a beneficiary.
Here, I should have said that. There's certain.
Oh, that's okay. I think that's sort of, it's a very important point, because a lot of people at home, if they could use anyone for a witness, you'd still be able to do these wills quite easily. You could send it to them by email. They'd ask their spouse or their child or whatever to sign them, and you'd be off to the races. I know what we've been having to do, which is not, necessarily possible or ideal for everyone, is a lot of our clients have been kind of handing it over the fence to their neighbor and having them watch and sign the document. And it's not ideal, but a lot of people are having exactly the problems that you are discussing. They can talk to a lawyer, they can have their will drafted, but they can't execute it. Now, I guess the other option is just to send them the typewritten contents of the will and have them copy it out by hand, but that's not really ideal either, is it?
So that is one of the suggestions that have sort of been circulating around the estates bar is, one is, they can handwrite their will. It doesn't really bode well for people. A lot of my clients that are perhaps elderly or arthritis, and, I deal a lot with complex wills that are not 3 pages long. Sometimes they're 23 pages long. So, that's not always a great option. I know the lawyers at Hull and Hull had come up with a really unique and sort of smart idea, I think. They posted about perhaps doing a holograph will and then incorporating by reference this typed up will as a schedule or an appendix to the holograph will. And I thought that was kind of an interesting and smart idea. Other than that, I really, haven't really heard much else out there.
No, I think what you've identified is exactly it. There's a problem with a couple of solutions floating around, which are admittedly quite innovative and smart, but there's no clear-cut answer. So maybe we can fast forward to, okay, we have this problem. We have a whole bunch of people who want to get their wills done, but they're having a hard time executing them because of the way that the legislation is written. Now, I guess one way to approach that would be to say, okay, let's change the legislation. Now, I'm happy to hear your thoughts on that. I know that Notice Connect recently put forward a petition, which we've signed. We supported 100%, which is asking to change the Succession Law Reform Act. But that takes time. It takes time. It's not going to happen tomorrow, and it's not going to help all of your clients or our clients or everybody's clients. So you have come up with a brilliant, what I would like to call a brilliant approach, which I'm very interested to see how it plays out this week. Maybe you can explain to us how you're approaching this.
So look, it's a difficult one for sure. But one of the things that I did a few weeks ago with one of my clients who were in that predicament of needing their wills executed and powers of attorney, they were not able to take the risk of having people come to their home unless it was their children who are beneficiaries, so they were automatically disqualified. They live in an apartment building in Toronto, so it wasn't like I could go to their house and look through the window like some lawyers are doing. I just couldn't do that. So we, you know, we sent the documents in plastic covers to the house. The wills were with the client. I did all of the review meetings and the correspondence and the sort of confidential meetings with the client through Zoom. And then the actual signing, I had my assistant who was here at my office with me present at the same time. We did a Zoom conference call with the clients. The clients showed me on the camera what they were signing so I could verify that it was each person was signing the wills that I had drafted and sent to their house. I, easily recognized them. And they signed the wills on Zoom. I could see it through the camera. The wills got back to my office. We did another Zoom meeting with my assistant, and I were both again together in my office. We then witnessed, I mean, the clients then witnessed us signing their documents. I mean, it wasn't as easy as some people would think. I think it took a lot of, took a lot of time. The technology was there, but we were nervous to do it properly and do it right and initial all the pages and sign. And so, at the end of the day, we recorded both of those two meetings. Those recorded meetings were part of the affidavit of attestation of the witness, which was my assistant. And those were exhibits to the affidavit that was submitted as part of our application. So we've been approved to be heard by the Ontario Superior Court this Thursday for a declaration that the process that we used was in fact met the requirements under the Succession Law Reform Act. And who knows?
That's great. That's really interesting. So just to summarize, you've essentially submitted an application to have the court recognize that witnessing the signing of these wills by video conference was a sufficient way to witness the wills. The wording of the act that the Succession Law Reform Act says that you have to be in the presence of the testator, the client. And nobody really has properly defined what in the presence is, but you're asking them to define it in this specific way for this specific situation. Is that accurate?
Yeah, I mean, I would think that the word in the presence of, my argument is that in the presence of could mean physical presence, but it also could include a virtual presence in some circumstances. And so it really is about what the judicial interpretation of the words presence means. And in our research, it really hasn't been a word that has been, properly fleshed out. But I think part of it is just a product of time, right? So time goes on, technology evolves, things evolve, the world evolves, and like the law, as you know, always takes many years to catch up to where reality is. So yeah, we're sort of like, that's where we are.
Absolutely. And I mean, I think that in a lot of ways, Canada is ahead of a lot of different countries in the world, but in a lot of ways we're not. So in this way, I know a lot of jurisdictions are already 10 steps ahead of us. Yeah. In the UK, they're able to do this. You have several jurisdictions across the United States that allow for, virtual commissioning and notarizing documents, which will hopefully become, actually legislated in Ontario, although we're temporarily allowed to do it right now. I think it's really interesting, and you're sort of pushing the envelope in the right place. So let's sort of fast forward to Thursday, because Thursday's the big day. I'm excited to see how it plays out. You're probably nervous, so I won't put the pressure on you, but we're really excited to see how that plays out. Now, so if you're successful on Thursday, and frankly, I think you're going to be successful regardless of what the outcome is. This is a question that needs to be heard. If the court agrees with your interpretation, let's say that, what does that mean for other people? What does that mean for other lawyers who want to virtually witness their clients' wills? What does that, can we generalize this? Can we start doing that? I mean, I know what our answer is, but I'm really curious what you have to say about that as well.
I mean, this is just me personally, but I think that, the declaration that I'm asking for is specific to my case and my clients. Mm-hmm. So whether or not other lawyers can use that as a precedent, probably. But, you know, it still may require all of these cases to bring this type of application to the court for their own case. Um, I really haven't really thought all the way through, but I do think it's important that people realize that the declaration that I'm asking for is very specific to my application. I'm not going to court asking them to, you know, make some sort of blanket ruling on the definition of the word in the presence of. I'm asking for a specific declaration that the process that I used in this specific case met the requirements of the SLRA. Now, can other lawyers use that as a precedent and follow that for their clients? Probably, but I'm not going to go so far as to extend my case to this is the way things are going to be done in the future. And I think that's an important a point that I want to make.
Yeah, that's great. I think, I mean, on a personal note for myself, I would agree with you. I think that the right approach, if we want things to change, is to change it legislatively. So I think you have a great case here. You've obviously been, you know, very, very careful, very cognizant of the potential risks. And this specific case, it needs to be done that way. So I think that just throwing a blanket allowance for this type of process to move forward without saying, look, you're allowed to do it, but you have to put these type of protections in place can be dangerous. So I think what's nice about this is if the court agrees with you, it just lends support to the idea that it can be done. Yeah. It can be done in a responsible way. So let's figure out how we can do this in a responsible way. And then let's change the legislation to match that so that lawyers, if they're responsible, if they're careful about, you know, ascertaining mental capacity, ensuring that there isn't duress, and that the documents are executed properly, et cetera, et cetera, et cetera, we can go ahead and start taking those steps so that our practice can catch up to technology and we can start to offer the services that people need. So great answer. I'm in agreement with everything you've said. And really, really just excited to see how this plays out.
Yeah.
Is there anything else that you wanted to bring up or talk about with regards to your current application or what's going to happen on Thursday or anything at all?
No, I think we hit all the big ticket items that I thought we discussed. There's going to be probably more to say after Thursday, so you know, I'd be happy to speak with you again, maybe in a couple of weeks, see where we land with all of this stuff.
Absolutely. Thank you so much for taking the time today. I know you're swamped. You're trying to prepare for this, and you being able to carve out, you know, 10, 15 minutes has been really helpful for everyone else, because I know a lot of people have questions. So yeah. Thank you a million. Best of luck. We'll be watching, and definitely would love to get an update from you after Thursday.
Super. Thanks.
Okay. Take care.
Bye.